Karen never missed a chance to stick her nose where it didn't belong. She strutted around the neighborhood like queen of the HOA, barking orders and quoting rules that didn't even exist. But this time, she outdid herself. It all started when she showed up on my porch one morning with a stack of papers in her hands and a smug look plastered across her face. "You're being sued," she announced, shoving the documents into my chest. I glanced down at them. "What for?" She crossed her arms. "For denying me access to your ranch property. HOA members are entitled to use the trails and pastures. You refused, and now you'll pay." I laughed in her face. "Karen, you've completely lost it. This is my ranch. I own every acre of it. You and your HOA have no rights here." Her eyes gleamed with false confidence. "That's where you're wrong. My lawyer says I can sue you for public access denial. And when I win, your ranch will have to remain open to all HOA members." I shook my head. Good luck with that. What she didn't know, what nobody knew, was that I wasn't just some random rancher. Before I retired, I'd spent decades as a high-powered attorney. Property law, litigation, contract disputes, I'd handled it all. And Karen had just declared war on the wrong person. I spent the next week preparing my case, pulling deeds, survey records, and land use laws. By the time court rolled around, I had a binder thicker than a phone book filled with documentation proving that my ranch was private property, untouchable by the HOA. Karen strutted into the courtroom like she'd already won, dragging her nervous-looking lawyer behind her. She whispered loudly to the neighbors who had shown up to watch, "Once this is over, you'll all be welcome to ride the trails." When the judge called the case, Karen's lawyer fumbled through some nonsense about shared community rights and public easement. It was weak. Then it was my turn. I stood, calm as could be, and presented my evidence. I pointed out that the HOA's charter had no legal standing beyond its subdivision. I showed deeds proving my land had never been under HOA jurisdiction. I cited state and federal case law establishing private ranch rights. And just to twist the knife, I included a notarized statement from the county recorder's office verifying that Karen had zero claim to my land. The judge flipped through my binder, nodding slowly. When Karen tried to interrupt, the judge shut her down instantly. Finally, the gavel came down. Case dismissed. Defendant's land is private property, not subject to HOA rules. Plaintiff is ordered to pay all court costs and attorney fees. Karen's jaw dropped. But I'm the plaintiff." The judge didn't even look up. "Then you should have done your homework." Couldn't resist. As we walked out, I leaned toward Karen and said, "That was me going easy on you. Next time you drag me to court, I'll countersue for harassment." Her face went beet red. The cherry on top, word spread fast. Neighbors learned the truth. Karen had wasted HOA funds on a bogus lawsuit that backfired spectacularly. At the next HOA meeting, she was voted off the board in disgrace. Now, whenever she sees me out on my land, she avoids eye contact. She knows better, because deep down, she's realized the one thing she can't control. I don't just own the ranch. I own the law. And when you sue a retired attorney on his home turf, you're going to lose.